Ben Hitchcock Cross talking to you today. We have the Kim Lavasseur decision here from the impartial hearing examiner, as we're going to call it here. So we've got the decision. I'm going to read it out, and this is going to, I think, bring up two big concepts here that really make this case interesting. So number one, Act 10, for those of you who don't know, geez, even more than 10 years ago, Scott Walker came in and really gutted labor unions. It's more than that, I would say, fair to say. Destroyed labor unions in Wisconsin, especially state sector employment unions, and changed much of the labor law for Wisconsin. And I'll note that nobody, including the Democrats, have really done anything to change that since then. So one of the questions there is, well, do state, really city workers here, county workers, do they really have any protections? So Scott Walker made a carve out to get the support of law enforcement. So law enforcement still has unions, but other employees don't. So these are the jail workers, and this question really is what are they? Are they at will or something else? Well, they sort of have some kind of due process. They sure do. And that's going to be a big thing that's playing here in the Lavasseur decision and what's going else. Because if they didn't have due process, if they were really at will, there wouldn't be a hearing, there wouldn't be a decision, and there wouldn't then be an appeal to the entire county board, which we're going to see that. We've got that tape there too, so we'll provide that coming up. So I think that's the number one thing. So what Act 10 then did is said all the counties, if they don't have a civil service system in place, they have to set up a grievance policy, and it's really got to have basically three things. One of which is you can't get fired without having a hearing in front of an impartial hearing examiner or something like that. There is no clear definition in the new statute for what the standard is. I think just cause used to be that. It's certainly not just cause. Even here, the hearing examiner seems to be unclear if it's at will or something else. And then there also is, let's say, the standard that they have written out here is unreasonable. So the question really is what unreasonable is. We submitted a legal brief to the hearing examiner on what unreasonable is. I don't think he used that in any way in here. But my point in that was it's not really clear what unreasonable is because we don't really use that term in this context except here, really, is what I'm saying. So my point is that to be reasonable, there has to be able to have some kind of decision that they can point to and the reason for making that decision. So that's a very low standard, but that's at least due process here. That's, again, you're going to have some fact, some decision, and some fact to back up your decision, okay? So if she's doing a bad job, you got to point to she's doing a bad job, and we don't want people around here who are doing a bad job, okay? Simple, that's a reason, got it. Okay, but the problem comes in, if you can't really point to one reason at all, which we're going to see, in her here. I think Sheriff Zupke and Executive Grady for Ashland County aren't clear on when they actually terminate her. I don't think the county board was clear on when she was terminated. Certainly the hearing examiner isn't. So that was one of our points was if you can't figure out what day she was terminated on, you can't say that there's a reason that you terminated her because you can't say on what the reason is and on what fact you relied. Okay, so that's the thing. You could say what the reason was. We say she did X, Y, and Z bad thing, and then at the same time we're saying, hey, we're pointing to this fact that backs that up. So we'll see what this hearing examiner has to say. Now, again, he's not a judge. With no reason to think he's ever been a judge. He is or impartial by any stretch of the imagination, but he's an attorney hired by the county to hear our evidence. Okay, so background. Oh, sorry. Here, let's bam and bam. There we go. This is the decision format. That's sort of the caption you can see there. That's not a court. All right, background. Kim Lavasseur was employed in the Ashland County Jail as the Ashland County Jail Administrator from May 2021 to January 19, 2023. On January 19, 2023, Lavasseur was terminated from his position as Ashland County Jail Administrator. There's a footnote there. Let's see what that says. Ms. Lavasseur's date of termination from Ashland County is different as discussed below. Well, it seems interesting. Okay. Huh. The termination was effectuated by letter dated January 19th of 2023. Initially, the county offered Lavasseur a position as a corrections officer. Ms. Lavasseur met with Sheriff Brian Zupke pursuant to the directive in Attorney Lindsay's letter. Kyle Cadet was also present at the meeting, which occurred on January 19th. As of the conclusion of this meeting, Ms. Blank, but assume Lavasseur, was offered to either accept the position of correction officer or to resign. Ms. Lavasseur indicated she would get back to Sheriff Zupke. Ms. Lavasseur then sent Sheriff Zupke an email on the 19th. In that email, she indicated, I would like to discuss via email my continued employment status. You state that you would like me to remain as a correction officer. What are the conditions of this offer? Please email me back with any conditions as I will be unavailable by phone. Sheriff Zupke replied on the 20th, please refer all questions to Max Lindsay. Ms. Lavasseur then replied to Attorney Lindsay on the 20th. Per the letter given to me, I tried contacting Zupke. I was told to contact you instead. The next email that is part of the record is an auto reply from Lindsay dated the 22nd indicating that he'd be out of the office. Fascinating. Until January 30th. On January 29th, Lavasseur sent an email to Attorney Lindsay indicating I have a doctor's appointment in the entire morning of January 30th. I should be done by approximately 1 p.m. I would like to speak with you regarding this situation. Thank you so much. There are emails between Attorney Lindsay and Ms. Lavasseur on the 30th establishing a plan to meet on 2:45 p.m. On January 30th, Attorney Lindsay provided Lavasseur with a letter dated 27th that stated, in my capacity as Corporation Counsel for Ashland County, this letter is in follow-up to my January 19th, 2023 letter and our meeting that day, and in response to your meeting with Sheriff Zupke. The county has decided to immediately terminate your employment rather than offer you the opportunity for continued employment as a correction officer in the Ashland County Jail. Pursuant to the Ashland County Employee Handbook and the statute, you have a right to file a grievance requesting a review of this employment action. So, I have attached a copy of the Ashland County grievance procedure to the letter for your review. I appreciate your cooperation with this matter and feel free to contact my office with any questions you have regarding this. Notice, Ms. Lavasseur filed a grievance on February 9th. Ms. Lavasseur describes her grievance as follows. I have no knowledge of why I was terminated on the 19th. State the reason for the termination. Failure to state a reason is irrational. The county, by its administrator, Dan Grady, denied Lavasseur's grievance in writing on the 16th, stating the following. Sharon Brian Zupke had several conversations with the current jail staff regarding the lack of involvement, professionalism, and leadership by Kim Lavasseur during the tenure as jail administrator. This is proven to be false, by the way. Because again, while he was the sheriff, he didn't have several conversations with her because they didn't talk. That's not true. They didn't talk, and except after he became sheriff. I think there was 3 days between when they did that and he initially demoted her. I think it was the 13th and then the 19th. She was out some of that time. So that's factually inaccurate. When Zupke was chief deputy, he observed that Lavasseur would regularly stay on the administration side of the building for multiple hours of the day and showed limited involvement in any direct management of the jail staff regarding enforcement of the jail rules, control of inmates, and ensure compliance with proper jail protocol. Well, in fact, the testimony was that Zupke was rarely there and Lavasseur was doing all the work. This lack of a direct involvement and oversight from the jail administrator allowed an atmosphere within the jail that jail policies and procedures did not need to be strictly complied with. Lavasseur's management of the jail operations and lack of control over inmates and correctional officers' adherence to jail rules has perpetuated an environment in the jail that is unsustainable and potentially dangerous. At least one correctional officer has tendered a statement of resignation directly citing the lack of control from the jail administration as the main factor in not being able to continue working in the jail. Through investigation into jail-related, we prove that to be false, by the way. Through investigation into jail-related incidents and conversations with jail staff, the jail has a perceived atmosphere where the inmates have control over whether the jail rules are followed, and the jail staff routinely fail to insist on compliance with those rules, further emboldening the inmates' actions. Lavasseur's lack of adequate management during her tenure as jail administrator has failed to address these critical issues. Lavasseur's management of jail operations culminated in an incident involving allegations of sexual assault between the two inmates. Max Lindsay totally wrote this, which ultimately led to her removal as jail administrator and termination of employment with the Ashland County. After investigating this matter, the sheriff's office identified several instances where jail staff failed to follow appropriate jail policies and where inmates likewise violated jail rules without consequence when confronted with questions as to the jail's investigation into those inmate allegations. Lavasseur did not take any responsibility for any lack of compliance with jail policies. Instead, Lavasseur deferred responsibility for compliance with jail rules to the individual correction officers and did not recognize her role in being ultimately responsible for the actions of the jail staff working under her administration. The lack of acceptance of accountability and deferral or blame to other jail staff is unacceptable from a jail administrator and was ultimately reason for deciding to remove Lavasseur from the position of jail administrator. I also want to point out here, this is after she had to file. So they terminated her. She filed a grievance without knowing why they terminated her, and then they made this statement as to why they terminated her, but they didn't, not before she filed the grievance, only afterwards. So again, failure to state a reason. This isn't their actual stated reason. This is what they subsequently said. So we all have to keep that in mind. That was clear at the time. It was clear to the hearing examiner, but, they get two bites at the apple. They get two chances. So in recognizing Lavasseur's shortcomings were mainly caused by a lack of adequate and effective management skills, coupled with long service with the jail to her position in jail administration, Sheriff Zupke recommended allowing Lavasseur to return to the position of CO on January 19th. So in fact, he didn't recommend, he decided that. That was his testimony. That was, okay. Corporation Counsel provided Lavasseur with a notice that she was being terminated as jail administrator and explained to her that the county intended to rehire her in her previous position as a correctional officer. Lavasseur was advised to meet with Sheriff Zupke to discuss her removal as jail administrator and the possibility of continuing her employment as correctional officer. In this meeting with Sheriff Zupke, Lavasseur again did not accept any responsibility for the incident leading up to her termination as jail administrator. Instead, Lavasseur stated that Zupke was not being truthful in his recount of these incidents, which we prove is true. Zupke specifically requested whether Lavasseur would like to continue her employment as correctional officer or to resign. I'm going to just zoom this for my benefit here, if you'll just bear with me. I think I can. Yikes. On the fly here, folks. There we go. Thank you. Zupke specifically requested whether she would like to stay. After this meeting, it was concluded that the trust between Lavasseur and the sheriff's office could not be regained. As a result, Lavasseur's employment with the county was terminated since she had not accepted continued employment as a correctional officer. Okay, and then we go over these rules, which we all go through there. Now, this is the important part here. Legal standard, and let's see what they have to say. The employee bears the burden of proof to persuade the impartial hearing officer by clear and convincing and satisfactory evidence that the county's decision to discipline terminate the employee did not have a rational basis. Of course, they did not give a basis, only before, only afterward, so that's problematic too. So how were we supposed to know what the decision was before if they didn't tell us? That's the problem, but not for them. All right. If the employee does not meet his or her burden of proof, the impartial hearing officer shall deny the grievance. This standard is set forth in the grievance policy, which was created pursuant to the statute in compliance with 2011 Wisconsin Act 10. Okay, so that's the Scott Walker, just like we were talking about. And so these are all statutes here that are saying you can't just fire somebody if they file a grievance. So much for at will. But that's what they have to say here is basically it's at will standard. So if they meet the at will standard, then it's rational. That's problematic, but we'll keep going. Hitchcock Cross asserted in his pre-hearing statement that the U.S. and Wisconsin Constitution prevent government actors from taking property from individuals without due process. Then Ben Hitchcock Cross cites Loudermill. Loudermill does not apply to Lavasseur Decision because she does not have a constitutional protected property interest in her job. Under Wisconsin law, employment is an at-will rule. Absent civil service regulations or laws. How about this one here? County grievance policy created pursuant to statute 66.05091M. How about, just like a law right there. All right. Our contractor collective and bargaining agreement. Municipal employee is an employee at will and has no property interest in his employment. Okay. We got that. 101 of the Act states, Ms. Loss, the policy is not a guarantee of employment. The county's employment relationship with the employee eligible as to use it is at will and may be terminated with or without cause, with or without noted at the option of the county or employee. Okay. Good for them, but then they still have a grievance policy that states, it has to be reasonable. So it's not at will. It's for any reasonable reason at any time. Yeah, okay. Was not a contract employee nor part of any union or position as the standard and burden of proof set forth is the standard in the county's grievance policy is the standard and burden that applies to this matter. Okay. Well, but so absent civil service regulations or laws. So that's the problem. It's not at will. It's reasonable. And she says it up here is rational basis. That's reasonable. Rational basis. Okay. That's what it actually is. So I get it, policy here, but it actually says rational basis, and it might say at will down there, but those two things contradict. How does he resolve the contradiction? He just says this. It's in the county's grievance policy is the standard. Okay. The issue of date of termination is not a critical element determining whether the county had a rational basis for her termination. Why not? But nevertheless needs to be addressed. Okay, but why not? Indicated that he did not terminate Lavasseur on January 19th, but decided after we met with her on the 19th that she should be terminated. Per Zepke, he slept on it and then decided she should have been terminated. It's worth noting that Zupke, while statutorily overseeing the jail maintained by the county, does not have the authority to terminate Lavasseur, who is an employee of the Ashland County, pursuant to Wisconsin Statute 59.118. The county administrator is the chief administrator of the county and does have the authority to hire. Where does it say that from the evidence? So part of the rule here was that they had to bring all this information in and have this evidence, and then that was the only thing that he could consider. But this is what he decided. So let's just go look here. I'll pull that up. 59-1802. Okay, dude. Appoint and supervise the head of all departments of the county except those elected by the people and except where the statutes, that's the sheriff. That's the problem there. So he doesn't say that at all. And in fact, the sheriff, will see here during the hearing that he says that they can't tell the sheriff what to do because the sheriff is a constitutionally elected officer and the county board can't tell him to do anything to do with his employees. So they're trying to have it both ways. So either Grady is in charge or the sheriff's in charge, but Grady says that he's in charge during the hearing, but then he says that the sheriff is in charge during the final hearing by the county board, which is problematic in its own sense, but we'll go over that at that time. Thanks for bearing with me on that. All right. Now, again, why is the critical element Lavasseur whether it's a rational basis? If you don't know when it happened, how can you say whether it was rational? That's a problem to me. I don't understand why that's not a problem to him. He doesn't say that, but maybe it's further on. It says there is nothing regarding employment status until the 27th, which is actually the 30th. So whatever testimony to the contrary, her date of termination should be considered the 30th. Well, so if there's testimony to the contrary and document to the contrary, that's problematic for rational basis, wouldn't you say? I would. Okay. Lavasseur indicates in her grievance that I have no knowledge why this might have been true at the time she was handed the 9th letter. However, after she met with Zupke, the meeting with Zupke was recorded, and Zupke and Lavasseur clearly discussed supervisory issues within the jail. Okay. But this does not appear to be a requirement for the grievance procedure. Okay. Upon receipt of a timely grievance form, they have 7 days to provide a written response, either granting the grievance or denying. The county timely responded to Ms. Lavasseur's grievance in writing. That doesn't mean that they have a chance. Does it say give her the reason for why she was terminated? No, it just says that they can either accept why she says, yes, you're right, or they could say, no, you're not right, let's have a hearing about it. The county's response denying Ms. Lavasseur's grievance has 3 paragraphs of what could be described as a general basis for termination, followed by 11. See, that's the problem. That's the problem. They admit right there. And procedure manual in Ashland County Jail Inmate Handbook. Okay, and the Ashland County Sheriff's Office Custody Policy and Procedure Manual, yada, yada, yada. Lavasseur contends that was not used, that the handbook was not even existent. That's true. Needed inmates to acknowledge the rules to be able to, okay, who followed, that was used. I didn't get him say that it was used and was on the desks of correction officers. Sorry. But okay, the county's response, the county did provide with her a basis for termination. Okay. Ultimate issue before the hearing officer is whether the counties, they did so, but even if you accept what he's saying, they did so after the fact. That's the problem. First, we terminated you, but we didn't give you the reason that we terminated you until afterwards. But that's the problem. And again, if her actual date of termination is on the 7th, and they're saying that she's demoted because of the jail issues and then terminated after he sleeps on it because she was a bad fit. That they don't tell her that she's a bad fit and they're going to have to sleep on it. See, that never happened. There's no discussion of that. It's a problem. All right. Although the county must only show that there is at least one rational basis for termination set forth in the county's denial of the grievance, this decision will view all the reasons asserted by the county. The first reason is a lack of involvement professionalism. To support this assertion, the county states, well, Zupke, again, what they're taking here is the decision after the fact of the termination. They don't get 2 kicks at the can. They were unable to provide a reason beforehand. They sent her a letter that did not provide it. And then after she filed the grievance, then they told her what it is. That's not how this works. That's not a reason. Sheriff Zupke testified that he felt Lavasseur was spending too much time on the administrative side of the jail. It was clear that at least some part of her role as jail administrator required to be on the administrative side of the jail. There was no showing how much time she was required to spend. Further, there's no indication, which is the job that provides guidelines that most of the time should be spent on the administrator of the jail, which leads to a subjective opinion of which is too much or too little. Okay. Lack of direct involvement. County's denial of grievance states, again, it's the denial that states. The notion that inmates become immobile is subjective and somewhat speculative because it is impossible to predict how the inmates would have acted if Miss Lavasseur continued as jail administrator. Okay. That apparently was unfounded. There was a verbal argument involving an inmate and another inmate. Okay. Now, the inmate told Lavasseur through Sergeant Wilbur and others that he had allegedly been sexually assaulted. Lavasseur notified Sheriff Brennan. Okay, there's an email from Scott, yada, 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 yada. It appears that there was another 2 weeks when nothing happened because the case was going to be assigned to Detective Pierce. Okay, Detective Pierce, and then proceeded to do an investigation. He watched several videos of jail video. I think he said he did it for like a month. But the report appears to be the basis of the following rule violations. Okay. Assuming Detective Pierce's summary of the video is accurate, there are clear violations of the above rules. Ms. Lavasseur testified while she had not viewed the video, she had no reason to doubt Detective Pierce's report. The recording of the meeting between Zupke and Lavasseur substantiates this claim. In the hearing of her grievance, Lavasseur's counsel spent a lot of time taking the testimony of witnesses and Ms. Lavasseur regarding the jail being understaffed. While staff may very well have contributed to the failure to enforce the jail rules, the fact that remains that the rules were not enforced. Okay, the county inserts that the following specific violations county to the office. Okay. Again, this is all after the fact. And she's saying they looked at, I think, 40 hours of tape, saw that inmates were doing some things that were violations of the rule, and then said, hey, there was rule violations. They didn't look to see whether or not she had done anything to correct the rule violations. They just alleged that it was all her fault, which, we contend was a witch hunt. But I guess he said something else. So for the allegations related to there did not appear. But there was no indication that she had seen the tape, that she was notified of anything about this, that they discussed that in this meeting whatsoever. The only thing I see them discussing is that she tries to say you knew about this before anything else, before the investigation. And he says, no, I don't even go there. No, I didn't. And all the indications is he knew plenty about it. This is Sheriff Zupke, knew plenty about the assault allegation. He certainly didn't do anything. Wilbur says he went in there and tried to bring him a policy manual to revise the policy instantly, and then he said yeah and took no notice of it. Seems like all they were doing was trying to get rid of Lavasseur. All right. Now, a reasonable inference could be made that Miss Lavasseur did not report her subordinates for not enforcing the rules in the jail, as there was no testimony about reports having been made. What? There does not appear to be any testimony to prove that these allegations were true or untrue. A reasonable inference could be made that Lavasseur did not report her subordinates for not enforcing the rules in the jail, as there was no testimony about reports having been made. Wow. I mean, just assume that that's the standard, and that all there has to be is some reasonable, because that says that we just have to show by clear and convincing evidence that it's unreasonable. But he's saying that it's possible that there were rule violations and that she did not report her subordinates for not enforcing the rules. Well, again, reporting them was not the only thing that was required to have been done. And it also doesn't say that she was required to report any rule violations. Okay. Complaints, that sure as heck was documented. Absolutely testimony in there that was reported. There absolutely was testimony from Kim Lavasseur that she disciplined her subordinates for not enforcing these rules. Absolutely was. Ms. Lavasseur, by her attorney, attempted to show that the county's basis for termination was not right, that it was mere pretext for numerous other reasons, including a conspiracy between Zupke and Grady and Corporation Counsel Max Lindsay, discrimination based on age, sex, and national origin, her attendance at county board meetings, her pointing out that the county administrator issues with the county budget. You mean that there was a huge hole in the budget that he hadn't fixed and hadn't told the county board about? The amount of compensation the interim jail administration is receiving. Ms. Lavasseur advanced an argument that her termination was a conspiracy between Zupke and Grady. This was an underdeveloped argument, but it appears that the alleged conspiracy was perhaps to discriminate against Lavasseur, who also alleged that her termination was discrimination and the reasons asserted by the county were mere pretext. Beyond Zupke, Grady, and Lindsay each having a role in this termination process, which is completely standard, there was absolutely no evidence that any of these individuals acted contrary to law. Okay, well, what law? Great. With respect to the discrimination complaints, made this claim based upon the fact that the person who was appointed to be the interim was apparently younger male identified as Native American. The mere fact that Ms. Lavasseur's interim replacement is of a different gender, age, or national origin does not in and of itself prove any discrimination, and Ms. Lavasseur offered no other basis to Mr. Cadot's appointment to her termination. Well, we did actually point out the fact that she had saved, I think, 12 people's lives immediately that he's appointed. Somebody dies in the jail. He's unqualified. He was getting paid more money than she was. He knew more about it. That's okay. I mean, the fact that he can write that sentence is kind of astounding. But okay. He, kept trying to tell me about his liberal credentials and everything during the hearing. Good for him. But my point is that sentence doesn't comport with reality. There was absolutely no evidence that any of these individuals, right. She did not identify, okay. To go over more proof of the fact, again, Mr. Kadat is his background is it's just the fact that he's completely unqualified. This is called there's direct evidence and indirect evidence, and there's the timing, the fact that it's immediate upon Zupke becoming the sheriff, he immediately takes these actions against her. I don't know. I don't know enough about Mr. Carlson's background, but he sure tried to assert that he was an employment lawyer. I don't see him doing the needed analysis here, but again, this statement that there's no other evidence is shocking to me. You can make your own decision. Those hearings are available online, but that seems to be a complete departure from reality. An employer is allowed to terminate or take adverse employment action for reasons other than an employee's sex, right? That's called pretext, okay? Here, or they could say non-discriminatory reason, but then we get to come back and say, that's false. Here, the county asserts that it primarily took its action based on the alleged sexual assaults that occurred multiple times while Miss Lavasseur was jail administrator. Miss Lavasseur, as jail administrator, had responsibility for ensuring that jail rules were complied with to reduce the risk of sexual assaults occurring. Miss Lavasseur does not dispute that these alleged assaults appear to be substantiated. No, she absolutely does. So do the police. What are you talking about? Nor that the jail rules were in fact being violated in relation to circumstances surrounding the alleged assaults. I mean, she doesn't dispute that that she discovered that there were jail rules being violated by her subordinates and that she took action about it. That's right. When she just found out what they were. That's right. That doesn't sound like a sentence by a person who listened to the same hearing that I listened to. Miss Lavasseur also made arguments that the termination was attributed to her showing up at county board meetings during the workday. There appears to be no merit to this argument, as Sheriff Zupke emailed January 16th indicates she can attend while off duty or by Zoom if it does not interfere with her daily duties. Another apparent argument advanced by Miss Lavasseur. Well, but again, if Sheriff Zupke isn't the decision maker, it really only matters what Grady's testimony was. And Grady didn't, really, dude? Really? I'm just saying, when your job is to be an independent hearing examiner, you got to examine everything at the hearing. And just saying absolutely no when I can rattle off 5 things is kind of astonishing. Kind of astonishing. The county budget, which apparently does not have adequate funding for capital improvements. Ms. Lavasseur believes she may have been fired because she pointed out issues with the budget to Mr. Grady. Ms. Lavasseur offered no evidence to support her claim that this was the basis for term. I don't know what he thinks that is any evidence. I mean, when you point this out, and then within less than, I think, a week, they start doing a secret investigation on you while your boss, going around the back of your actual boss. And then 3 days when the new guy comes in, they terminate you. And that's no evidence? I don't know. That's a shocking statement to me. Another argument advanced was Mr. Kadat. That's the man who replaced her and then got into a 1-car drunk driving accident, I think 3 weeks later, and then had to resign. Wasn't terminated, had to resign. Wasn't terminated, had to resign. Apparently, he is being paid hourly and receives additional benefits of being paid as a sworn deputy. This is an illogical argument. The alleged fact that Mr. Cadet is costing the county more would be a reason not to terminate Miss Lavasseur. Even according to Miss Lavasseur, it is costing the county more not having her as jail administrator. Okay. Okay. Per the grievance policy, if the employee does not meet his or her burden of proof, the impartial hearings officer shall deny the grievance. The county had one or more rational basis to terminate Miss Lavasseur. Okay, well, there you go. The jail rules were violated by inmates, and those violations occurred under her supervision, who was then acting jail administrator. Consequently, Miss Lavasseur did not meet her burden, and therefore her grievance is denied. However, her date of termination should be considered the 30th, and the county should ensure that all wages or benefits are paid to Lavasseur through the 30th. All right. Well, stick with us. We will have the hearing of the deliberations, I guess I should say, of the county board, and we'll see what shenanigans happen there. All right, stick with us. We'll keep you informed. Thank you.